Hello. Welcome to a podcast on the law and its impact on computing technology and business. This is Brian Gaff. I'm a senior member of the IEEE and partner at the Edwards Wildman Palmer law firm in Boston. The IEEE is presenting this podcast in conjunction with my column that appears each month in Computer Magazine, a publication of the IEEE's Computer Society. That column discusses legal issues relevant to people in the computer hardware, software, networking, and service businesses. In the last podcast, I discussed patent monetization. In this podcast, I'll discuss inventorship, a topic that I covered in my May 2013 column in Computer Magazine. The first issue is what is meant by the term inventorship when used in the patent context. Under U.S. patent law, an inventor is a person who conceives an invention. Now that begs the question, what is meant by conception? This is also a murky legal concept. To paraphrase the court, it defined conception of an invention as the formation in the mind of an inventor of the complete and operative invention. In many cases, it might be obvious to determine who the inventor of a particular invention is, but there are other instances where it may not be so easy to determine. Sometimes inventors are the people who, for example, develop the original schematics or flowcharts of an invention, or in the chemical world, define certain structures and formulas, or in the biotech world, define certain genetic sequences. The people who originate that material sometimes might be considered an inventor of their particular patents. Now, there's another concept that you might have heard of called reduction to practice. Reduction to practice can either be actual or constructive. This is a legal term, and it corresponds to the preparation of an actual working model of the invention or a prototype. That is, if you actually build your invention into an operative item, that's called reduction to practice or actual reduction to practice. Constructive reduction to practice is usually referring to instances where you file a patent application on your invention without having manufactured it as a prototype or as an actual production model. Reduction to practice is usually not required to prove conception and inventorship. It sometimes comes into play when you have unpredictable technology, like certain biotechnology. But in most instances, there is no requirement to reduce an invention to practice, that is, to make an actual operating model of it. Now, while it is difficult to define what is convention in the practical sense, some of the things that usually do not qualify as conception are following instructions, suggesting a result, or supplying starting material or something else that's known. The folks that do these particular things are generally not considered inventors because they generally have not been in a position to conceive an actual invention. Now, one thing that's changed with inventorship very recently, on March 16, 2013 to be precise, is the shift in U.S. patent law from what's called a first-to-invent system to a first-to-file system. Before March 16th, the person who first invented a particular item is the person who was considered to be the inventor. That changed with the new law that took effect on March 16th. Now, the first person to file a patent application in most instances is considered to be the inventor. So one thing to keep in mind with this change in the law is that you are no longer afforded the luxury, in most instances, of not disclosing your invention to the patent office in the form of an application and then hoping to be able to get a patent as a result. You may find yourself having been beaten to the patent office by someone else who is working in the same technology area, another research competitor, for example. So it is very important that today, when you conceive an invention, to work quickly to get a patent application on file. Most likely that could be a provisional patent application, which is usually a low-cost, easy-to-assemble document that can be submitted to the patent office and effectively allows you to put a stake in the ground as to when you invented your invention. If somebody comes along after the fact and files a patent application on the same invention, your pre-existing provisional application should trump them and allow you to retain your designation as an inventor. Now, how is inventorship described to the patent office? How does the patent office know who the inventor is? Well, that's done through a form that's filed in the patent office called a declaration. And this is a form that each inventor signs, as the name implies, declaring that he or she is an inventor of the subject application. It's signed under oath, and it is a very critical document that must be submitted to the patent office. Now, what happens if certain inventors are not available to sign? Let's say the invention occurred some months previously. You're assembling the inventors, and one or more of them cannot be present to sign the declaration paperwork. Maybe they've changed jobs, maybe they've become incapacitated, or maybe they're just not cooperating. Well, previously, under the older patent law, this presented certain difficulties for the other inventors and the ultimate owner of the patent, which would be the inventors themselves, or it could be the inventor's employer. Under the new patent law, however, there are instances where this unavailability of inventors is addressed and applications are allowed to proceed more expeditiously than compared to the previous law. However, you must keep in mind that there might be some documents that would obligate an inventor to assign his invention to a particular agency. For example, a very common case is when an inventor works for a corporation, and that corporation has an employment agreement with all of its employees, and as part of that agreement, the employee is required to give ownership or assign any inventions he or she makes over to the employer as a condition of employment. Sometimes invention disclosure forms that companies use, where an inventor makes a brief description of his invention. That document sometimes includes a statement indicating that the ownership of the invention lies with somebody else. Again, the employer, for example. And there may be other agreements that are executed under certain conditions, separate agreements, for example, where an inventor would be obligated to assign a particular invention or all inventions over to another entity, such as an employer. In any event, if those documents are available, and if the corresponding inventor is not available to sign a declaration, those other documents can be used to support the owner or the assignee of the patent as the person who will take control of the application and proceed with it through the patent office in the absence of the missing inventor. Keep in mind also that in the context of inventions made during employment, whether those inventions are owned by the employer or may be owned by the actual inventors themselves. This is another very murky area. Sometimes employees are making inventions on their own time, using their own resources, and staying outside of work when working on those inventions, the prototypical garage inventor. In those instances, employers may not have any claim to the invention. On the other hand, if the invention is closely related to the employer's work and closely related to the employer's products, the employer may have a claim on them. In any event, it's important to scrutinize any agreements that you might have that will describe who owns inventions, because those documents could become very critical when a patent is being prosecuted in the U.S. Patent Office, that is, during the time the application is pending and working towards its goal of becoming an issued patent. Sometimes the owner of that patent, or the ultimate patent that would issue, would have a significant ability to control that prosecution, which is very important, obviously, to what results from that prosecution specifically, what kind of patent comes out of it. Another concept to keep in mind is the concept of joint inventorship. Joint inventorship, as the name implies, involves instances where more than one person is involved with conceiving an invention. More than one person is responsible for conceiving an invention. In most instances, that can be pretty easy to determine when more than one person is involved. However, this is an issue that has been litigated vigorously, and it's important to keep in mind that everybody who is named as an inventor on a patent must have contributed to at least one claim in the issued patent. This does not include people who are simply being named out of courtesy or protocol, or for any of the reasons that you might want to name somebody as a co-author on a scientific paper, for example. Determining inventorship is much more rigorous than that. And if there are mistakes made in naming inventors, well, those mistakes can put the patent at risk of being found invalid. There are ways to correct the inventorship, and it can be done fairly easily if all of the people named on the patent, as well as the people who are about to be named on the patent, for example, all agree as to why there needs to be a change and agree to state that there was no deceptive intent in the error that caused the problem to begin with. However, keep in mind that you must maintain correct inventorship on the patent. It's important to verify that the inventors named are correct when that patent is getting ready to issue. If you need to make changes, do it before the patent issues in order to save time and money and aggravation in doing so after the patent issues. I hope you found this podcast helpful in understanding some issues about inventorship. This is a tricky concept, and it requires a serious discussion with your patent attorney whenever you file a patent application to ensure that you avoid problems downstream. Until next time, this is Brian Gaff. Feel free to contact me via email at bgaff@edwardswildman.com. Thank you.